Good day and welcome to our session today on effectively navigating the legal maze involving divorce. Before we officially get started, welcome to our session today. My name is SchoemanLaw. I am one of the panel members, one of your presenters in the session today. I'm joined by esteemed colleagues, each of which brings a very different perspective and focus area of expertise to the table, hopefully enabling you to navigate what we all know is an extremely difficult journey that you may be facing at this juncture. In today's session, we are going to take you through a number of concepts you may or may not as yet be aware of, or you may or may not have an opinion or perspective on. Firstly, we will deal with the proceedings of the divorce action. We'll also distinguish between opposed and unopposed proceedings. We'll also go through what it means to have an antenuptial contract and how it fits into the process. We'll take you through spousal and child maintenance. Then we'll look at the usefulness of mediation within this process. And last but not least, we will leave you with some thoughts around your estate planning and some of the changes you may want to make as you are planning what is probably going to be a different future than you may have envisioned just a few weeks, months, or years ago. Now, before we get into the nuts and bolts of what it really means to go through divorce proceedings, and before we open the floor and I give my colleagues an opportunity to share some of the processes with you, and we take you through each of the options and what to expect from this process. I want to start off by saying that we've all heard horror stories of divorces that have taken excessively long, that have cost a lot of money, or where it has just been a traumatizing experience all round. And of course, there are many reasons that may result in that. And because of all of this and some of the stories we've heard as legal practitioners, we've decided to present this session to help others know what to expect, to go into the process, which by all accounts is a really difficult situation, no matter how we look at it, and to have a little bit of clarity and certainty as we embark on this really tough road ahead. Divorce, no matter how we look at it, is one of the most difficult situations to navigate probably in most of our lives, particularly and more so when we are parents. Therefore, it is important that you choose a legal team that understands this challenge and your specific situation and some of the things that are important to you as we go through this process. And that in turn should enable the team to better support you through the process and to ensure that we ultimately achieve the outcome that is desired. Now, I want to go into some of the thoughts that I would like to leave you with as we go into the more procedural components, and before, of course, I hand over to my colleagues. I am a specialist commercial attorney. I am also a notary public and a mediator, and therefore I am not actively involved on a day-to-day basis in our family law matters. But one thing's for sure, negotiation is a part of life, and it is actually a very insightful academic sphere. And therefore, I felt I wanted to share with you some of the thoughts around analyzing the situation we find ourselves in today, and particularly in this context. And I think if we do this, we go into it with a very different mindset, no matter what the emotions may be that we are experiencing right now. So firstly, is this a win-win or win-lose situation? Now, this is a really difficult question, particularly when children are involved. I would like to say then it should be a win-win situation where there should be a level of compromise. And it would follow that there would be a continuous relationship that would need to have some way of functioning in a more healthy way. Who is representing on either side? Who's representing you and who's representing your ex-spouse or soon-to-be ex-spouse? Who are all the interested parties or stakeholders? In a broader context, from a representation point of view, from a family point of view. This is really important because these role players all have influence in how we show up when we start working our way through the process. What is it that we would want to achieve in the first round? And I want you to retain that thought as we navigate into the mediation space a little bit later. What are some of the alternatives if we can't meet each other halfway? Will this then become a long, drawn-out, painful, more traumatic process than it already is? So we need to know from the start what is at stake. What do we want out of this? Ultimately, what's the one thing we want to achieve with the first round of interactions? And I challenge you to think about these things as you are preparing to have that initial conversation with your legal representative. Now, without contradicting what I've said, and without going too deeply into this concept of negotiation, facilitated negotiation, or mediation, and the theory and the tools that we use, because it really is the value we bring to the table, I would like to share some tips with you in relation to noticing where we sit when we enter that room, whether it's formal or informal. In other words, whether we call it a mediation or whether it is just a meeting or a roundtable meeting, so that we can narrow some of these issues. Now, it is important for us to analyze, to get to the point, to be mindful of all the components that we walk into this room with, for us to try and package our own thinking around getting from the aspiration base to the real base. And importantly, we do know that some of these meetings do not happen face to face. Some of these meetings happen online, and therefore that some of the theories that I'll be sharing with you shortly may not be exactly applicable in that particular situation. If we are dealing with a physical environment, it's important for us to look at where people go and sit around the table, and for the legal team to take charge of where people sit and maybe show them, please sit over here, you may have a seat over there. Now, if you look at some of the pictures, we're starting with the picture on the far left, figure 3.1, where you have someone sitting at the long end and the head of the table. That is one of the most collaborative positions. 3.2, right next to it, seated next to one another, probably not appropriate for the first meeting, because that is the most inviting, most peaceful, most collaborative of them all. Now, the previous one, 3.1, where I said is the most collaborative, it is the most collaborative with healthy boundaries. Maybe I should add that. Whilst you have the position seated next to one another, that is usually very comfortable, very friendly, and often not seen in a professional situation, often also not seen in most family law situations, including divorce. And then, of course, we've got the 3.3 just below, where we are adversarial, we are facing off on each other across from the table. And then the most acrimonious of them all being figure 3.4, where we are not even directly engaged in an adversarial battle. We are also not seeing eye to eye. In other words, we are not sitting directly across from one another. We are so angry and so acrimonious that we do not even want to face each other head on. So that 3.4 is the most likely position if we don't bring into 3.1, or at the very least plan B 3.3, then we are probably set up for disappointment. Now, positioning on where you sit can also be practical, but remember there's a component of this that works on the mind. And that is why it's important to take charge and to decide if you are hosting, or to ask, may we sit over here if you are not hosting? So as to, at the very least, get everyone into a 3.3 position and hopefully into a 3.1 position. Now again, you may now ask me if there's a legal team and myself and a legal team and him or her on the other side, who sits as 3.1 or 3.3 if we have multiple people? It depends where the actual decision making is going to lie. Who is going to do the talking and make the decisions? Where does the power lie in the discussion? And if you really do not know, it is important for you to at least have that as one of the components that you would want to find out as part of the objectives of the first meeting. Maybe make some other practical arrangements and reconvene and then seat appropriately. Aim for 3.1 because that's where we can really connect. There's a boundary, there's safety in that boundary for the parties concerned, and we can actually make this work. But each scenario will really direct on where we sit, how we sit, and how we set up. And that is why it's so important for us to really understand the landscape as the legal team. I'm going to hand over to my colleagues now, and I really hope that this segment, just to think a little bit more mindfully around how we show up, has been useful.
Hello, my name is Celeste and I'll be discussing unopposed divorce proceedings. An unopposed divorce is the best option if you can make it happen, is to do your divorce in an unopposed manner. An unopposed divorce is one in which you and your spouse work together to agree on the terms of your divorce. You will both consult the same attorney who will be unbiased and impartial. In an unopposed divorce, the parties agree prior to the divorce on how to divide their assets, and if there are children involved, which parent will become the parent of primary residence and which parent will be the parent of alternative residence. The court issues the summons and the sheriff serves the summons on the defendant. The summons specifies the number of days in which the defendant has to file a notice of intention to defend. If the defendant does not answer by way of a notice of intention to defend within the time frame specified within the summons, the plaintiff may then approach the court to enroll the divorce on the court roll and conclude the divorce on an unopposed basis. Settlement agreement. What is a settlement agreement? A settlement agreement is a written document that highlights everything that you and your soon-to-be ex-spouse have agreed upon. The agreement lays out the conditions of the divorce and needs to cover three main topics: care and contact, child and spousal maintenance, and the division of property. A divorce settlement agreement will ultimately be made an order of court. Care and contact in the divorce settlement agreement. It is recommended that the care and contact arrangements are detailed in the divorce settlement agreement, no matter how amicable the divorce may be. There are various forms of care arrangements available. Contact or visitation rights and responsibilities also need to be highlighted. In most cases, both biological mother and biological father have full parental rights and responsibilities in respect of their children or child. Biological parents have the responsibility to care for the child or children, to maintain contact with the child or children, and to contribute towards the maintenance of the child. Biological parents have the right to contact or visitations with their child, which needs to be clearly outlined in the divorce settlement to remain fair and to avoid disputes. Issues such as detailed holiday schedules, birthdays, special holidays, etc. need to be clearly stated. Child and spousal maintenance in the divorce settlement agreement. A principle of marriage is the reciprocal duty of support by the parties according to their means. Spousal maintenance is money that is paid from one spouse to another to help support them during or after the dissolution of marriage. It is usually the male spouse that is expected to financially support the female spouse, but this is not always the case, as women have become more financially stable. Spousal maintenance can become payable in one of two ways. The parties may come to an agreement in a divorce settlement, which will later be made an order of court upon divorce. With the second option, in the case where the parties cannot come to an agreement, the court will make an order after the parties have presented all the relevant evidence in court. Child maintenance refers to the money that a child is entitled to in order to have the clothing, housing, education, food, and medical needs met. It is the responsibility of both parents to provide for the child's needs, but in practice it is usually the primary care parent that receives the child maintenance monthly to ensure that the child's needs are catered for. Division of property or assets in a divorce settlement agreement. The last main function of the divorce settlement is to determine how the property or assets will be divided between the spouses. This division will depend on the way in which the parties are married, either in community of property or out of community of property and with or without the accrual system. However, property or assets can be divided in any way that a couple agrees on, which needs to be outlined in the divorce settlement. Decisions will need to be made regarding whether or not certain assets will be sold, such as a house, and if whether or not the profits will be divided. In certain cases, the parties may agree that one spouse will buy the house from the other. If the house is kept by one spouse, then it is that spouse's responsibility to change the bond into his or her name after receiving the divorce decree.
Hello, my name is Robin and I will be discussing the contested divorce proceedings. A divorce is usually started by way of a summons, and this is when a summons has been issued by the court. The summons informs the defendant of the plaintiff's claim and informs the defendant if he or she wants to defend the action. Then he or she needs to enter into a notice of intention to defend. Now, the summons must comply with a few formalities, which must state the following: the sex, the occupation, and the address of the defendant, as well as the plaintiff, and the full address where the plaintiff will accept service of documents. Before a summons can be issued, the following must be addressed in the particulars of claim. Firstly, the grounds on which the court has jurisdiction. If a marriage subsists between the plaintiff and the defendant, the place and date of the marriage, as well as the matrimonial property system, the name, ages, and sex of any minor children, if there are any, the name and address of the person in whose care the minor children are, and the nature and ground of which each claim is based on. The summons is then signed by the plaintiff or the legal representative and must state the address of the person who has signed. A summons and any other pleading may be amended at any time before the judgment, and a summons is then personally served on the defendant by the sheriff of the court, and a return of service will then be produced by the sheriff. Once a summons is served on the defendant may, within a period of time, defend the action by delivering to the registrar a notice of intention to defend. This notice must then be signed by the defendant or the attorney and must state the full address where the defendant will accept service of any further pleadings and notices. After serving a notice of intention to defend, the defendant must, within 20 court days, deliver a plea. The plea must be dated and signed by the defendant or his legal representative. In the plea, the defendant must either admit, deny, confess, or note the material facts which are alleged in the particulars of claim, and must clearly state the nature on the grounds of his defense. The defendant will then deliver the plea timeously. Essentially, the plea contains the basis of the defendant's defense, and the defendant may either, once again, admit, deny, confess, or note the allegations. If a defendant fails to deliver a plea, the plaintiff may deliver a notice in writing calling upon the defendant to deliver a plea within 5 court days. This is referred to as a notice of bar, and warning the defendant that failing to do so will result in the case being set down without further notice. The defendant may also deliver a counterclaim or a claim in reconvention, setting out any counterclaim that he or she may have. If the plaintiff
Now you may
intends
feel
My name is Johan
that
Duane,
there
and
is
I'll
a
be telling you a little bit more
fairly
about the
strange
post-divorce
incision
proceedings
in
should you not
our
have been able to
today.
reach settlement,
to the
as was discussed
counterclaim
above.
Because you
Now,
are already married.
Generally, you would then
and
head, if you have now
once
are no
already
longer
plead
interested
and
in
filed a
how
counterclaim, so this would
may
be
have
depending on
been
who
or
obviously
may
could have
institutes
been,
divorce proceedings,
because we are
you'd
now
head into
staring
what we
down
call the
the
discovery
barrel
stage.
of
So this is when
court.
pleadings are closed.
Once
Now, the
this is
discovery
done,
stage is where you
anti-nuptial
request
contracts
the
are
relevant
super
documents
useful tools,
to the
particularly if
divorce.
they
So
are well
that would be
drafted
the
and
list of the
properly
assets,
executed.
list of
Now, what do
expenses,
I mean by
lists
that?
further,
of
I mean
things that you would
that
take into
certain
account
things
should
have
you
to be
need
in
to
these
calculate
agreements. They
accrual
have to be
or
an
anything
cited
relevant
in
in that stage.
components. They have
This
to
would
make
happen by
reference to
filing a notice. It's
subsections. They
called
are
a discovery
similar
notice,
to
in which you request the
consider
other party to
components that have
discover,
to be
and then
worked
that
into
party would
it.
have to file what we
But
call
that
a discovery
aside,
a trial
affidavit.
it
commitment.
Now,
often
in the
also
discovery
gives us
And
affidavit,
this is
you
whereby the
list
parties
all
or
the
the legal
documents which
representative
you want to
you
will be
discover,
given an
which you
would it
feel are
be
opportunity to
relevant.
appropriate to
deliver
do
an open and
Now,
at
shut
both
this
parties would
stage?
need to do
in
this.
which the court
And
is
And
then,
it's
informed
very
of the
should you look
issues
at the
that are
list that the other
need to
party
mention at this
discovered,
point
and
already.
those
you
which
can
may
then
Back
decide,
dispute.
are there other
on
documents
And
that you
you
are
would then
aware of
do
that
the
weren't
burden
discovered, and you
of
can even
proof
then
is on
why
the
is
request
it
defendant
those
important to
documents
them,
and
why
say
certain
you are
facts were
requesting
the
further
burden of
not
documents
proof is
which
on the
you are
represented.
plaintiff.
aware of
The
that they
plaintiff
now
may
need
give
to
evidence
discover.
You
first.
Now, this process is usually
are
where you
not
actually
sure
look for the
about
relevant
that.
information in
To
order to
either
Go
prove
voice
your
out and
claim
first,
in the
try
divorce.
and get
may
So, if
address
you're
the
saying that there are certain
notary or
assets
the
that
and the
exist
other
that need to be
attorney
party
taken
then
into account to be
does
has
the
the
divided
drafting
equally,
charge
of the
this is where you would
agreement
request the information in
to
order to determine
judgment
the value
advise
of
accordingly.
those
us
assets
The
and so
court can
forth.
hand
either give
over
the
the
Now,
following
file
once
judgments:
to
both
judgment for
parties
a
have
party
discovered,
reunite
in
if
then you can
respect of
actually
his
relevant.
or
head
her
into
What the
what we
claim,
call
thinking
the
was is that
pre-trial
insofar
phase.
as
Now,
the
at the
behind certain
pre-trial
pleadings.
phase
decisions that
is
were
when
taken
we
and
Judgment
included
for a
in the
essentially
party
look
court.
in
at where
Now,
are
respect
we
of
in
his
the
or
from a
her
matter, what
formality
still
point
claim,
of
needs to
view,
happen,
an
are
an
there any
anti-nuptial
insofar as
admissions
contract
that need to
must
be
be
made
signed
between the
before you get
parties,
married.
or
what is
absolute
the
must be
time
truth
frame
registered
that
in
we're
this
working
case.
with.
if the court
You know,
appears that the
you
evidence
would
does
That
essentially
not
come
justify
together
conjunctional
at what we call a
post-nuptial
pre-trial
recognition is
conference. Now,
possible,
judge
but
there's
is
two
there's a
things.
certain
There's a pre-trial
process
conference
that
between the
that would
two
that
need
is
to
the
follow.
relevant
process of
legal
And
contested
representatives.
if
This
it
usually
were
divorce.
happens without
not
the clients.
However,
It's more for legal
one should
practitioners to
also
do.
executed
take
properly,
into
a
Just in
account
consent
terms
would
of
have been
how we
signed, but
and
determine
a
the
under
conduct
consent
of the
interim, the
matter,
agreement
leads officer,
then
for
what we'll
is an
do is we'll
agreement
example,
which
conclude
both
there
parties
what
is
we
have
call a
thought that
joint
it may
pre-trial
still
minute.
in
That
find
will be
respect
application
of
submitted
and
appeal
to
still be
the judge
conduct
that
useful,
gets assigned
although
to your
in a
case. He will
limited
in
then
respect of
context
the
in
essentially
divorce
immovable
proceedings.
property,
review that
immovable
and
So
property,
determine,
if there are
as
okay,
well as
issues,
being
we
due.
will
where
have
are we
to
in the
Now,
matter?
mobilize
Has
this
the
and
is
work
timelines been
signed by
worked
with
out?
both
What
the
admissions are
parties
defense as
as
required?
we
well
start
You
the
as
know, have we
process.
worked
And
on any
then
of the
and
issues
signed
that
by
still
the
the
need to be
first question
determined?
I'm
defendants as
always
well,
asked
At
is,
that
possibly
you
stage,
two
he will
know,
then decide,
witnesses.
is
if
this
I
And
matter
once
don't have
that
pre-trial? Is this
wonderful
consent
matter
agreement
trial
has
capacity,
been
ready
community, and
or is it
finalized,
not?
property, which
the
So
means
parties may
should
set
certain things still need
everything
to
down on
happen, then
one
I
he will
location,
have,
certify that, okay, this is
whether
the
and the
that
court
is
timeline
will
an
then
and
asset
this is
grant a
the
or
what
divorce
in
the parties must
decree
agree
obligation
to
or
do by a
incorporating
literally
certain
the
date
liability,
in
terms and
order
which
to
shared
conditions
be
equally
of
trial
the
between the
ready.
lease.
spouses
Once
in
everything
this
has been
one
completed,
indivisible
the
joint
judge will then
estate.
determine, okay, this matter is
If
now
the
trial
anti-nuptial
ready,
contract
and he
is
will allocate a
invalidated
trial date.
completely,
Now, at
because
trial, essentially what
amongst the
happens is this
fact that
is
it
where you
doesn't comply
argue
with
your
all
case.
the
Now, you have all the
formalities
relevant
that are
information
prescribed,
available to you. Both
there
parties have
may be
pleaded.
something in
So
it that
usually
is
the
legally
plaintiff will go first.
unenforceable
They'll
and goes
state
to
their
the root
case.
of
They'll
the
use the
agreement,
evidence that has been
which then
filed in terms of
invalidates it, and it
discovery in
takes
order to
us
prove their
back
case.
to a
And then
marriage in
the
community and
defendant
property.
will then have a
Now,
chance to obviously rebut
if
that and
there is a
state their
valid
case and
agreement, there's
use the
no
evidence which they've
real risk
discovered
of
and
this
the plaintiff has discovered in
eventuality. It's
order
about
to state their case and
looking
make
at the
out what they
ingredients of
want
the
from
agreement,
the
whether
matter
they are all
and in terms of
intact,
obviously their
and
counterclaim.
whether the
And then
agreement
that will go
is,
on. Depending on how
whether we
complex
are
the matter is, it
able
could take a day or two,
to
and that's determined
actually
by the
follow
legal
through on
practitioners
the
and by
provisions of the
the
agreement.
judge during the pre-trial phase.
Essentially, there are two options when
So
it
once
comes to
trial is
anti-nuptial
completed, then what will
contracts,
usually
either to
happen is that
include
the
the
judge or the
accrual
presiding
system
officer will
or
sit.
to
He will have
contract out
listened
of
to both
and to
parties and they would have
exclude
filed
the
heads
application
of
of the
argument
accrual
in regards
system.
to that.
In the next
And he
slide,
will
I'm going
determine,
to
okay,
explain
what
to
is
you
the
very
order that he's
roughly
going
how
to
this
make.
works from an
Now,
accrual
it's at
point of
judgment
view,
phase, specifically in
and
divorce
just so that
proceedings,
you've got
where
some
he will
idea
determine,
as
okay,
to how
now
that
the
works
parties
and
are
how it could
divorced, and
potentially
these are the
apply,
terms of the
maybe even
divorce.
give you some
Essentially,
direction
how
as to
accrual is
some of the
calculated,
information we would
how
need
will
to collect.
maintenance work, and so forth.
So how does
Depending
this
on what the
really
case is
work?
and how
Well,
clients
as we
obviously and what
draft
they
the court
want, the judge
papers,
will look at it and he
we
will
would make
determine
reference
what
to the
is
anti-nuptial
fair and
contract. It
just
will
in the
also form part
circumstances in order to make an
annexure
order to that
to
effect. And
the
that will be
court
your
papers,
judgment. And
and
essentially that
we
will
will
become your
try
divorce
and
order.
do
On that
what
day when
was
judgment is
agreed
delivered
in
and you
there,
receive the
unless,
order
of
is the day
course,
that you are
as
actually
part
officially
of
divorced.
settlement
And the terms of
negotiations
that
or
order will
mediation,
dictate how your
we
divorce
choose,
carries
we
forward and
being
in
both
a sense what the
parties,
terms of your
choose to
divorce are.
deviate from the
So that
terms.
is very reliant on
But I'm
obviously
getting
if you
ahead
got
of
married with an
myself.
antinuptial
Let me
contract,
explain
then
how
that
the
will play a heavy
accrual
role. If you
system
got married
operates
in
on a very
community
high
of
level
property, usually
so
they'll look for a
that
clean split,
you can
but
get some
dependent
of
on,
the
the circumstances,
information
they'll
that
determine,
may be
how will
required
maintenance
ready,
work and so
and
forth. This
that
will all
you
be
can
argued
jot
during the
down any
trial phase,
questions
and
you
then
may
the
have.
final decision will
Now,
be
I
made during judgment.
usually use a fairly extreme example to illustrate the principles of the accrual system when I explain it to clients. So please bear with me and note that this is really for purposes of illustrating the principles. Let's say two people are married, A and B, and now the marriage has come to an end, which can occur either through death or divorce. So in this case, it will be through divorce. Now, A comes in with a commencement value of 10,000 Rand and B with a commencement value of 100,000 Rand. Now, these values would have been agreed in the antenuptial contract, either by way of itemizing all the items that got to the total of 10,000 and 100,000, or could simply just be a total in the agreement, right? This is adjusted in accordance with the time value money principle with the CPI, meaning that we'll adjust the equivalent value of the commencement to value in today's terms. Now, this will happen as part of the process, and we will assist you through that process if you choose to work with us. Let's say at the end of the marriage, A ends up with 100,000 and B with 1,000,000. And let's also just leave it as is, just for sake of illustrating the principles, so that we don't have to crunch numbers in too much of a complex way. If we look at this just on face value, clearly B's estate has grown substantially more, shown a accrual exceeding that of A, meaning B will be the person who has to do the sharing under the accrual system. So that means there was a 900,000 Rand accrual in B's estate, and B will have to pay A as follows. 900,000 minus 90, which is A's accrual. That gives us 810,000 Rand, and that divided by 2, which is 405,000 Rand, is what B will pay to A. Now, in most instances, it may happen that this is not a cash position and there may be a shortfall. And this is potentially where negotiation would need to take place or arrangements would need to be made as part of the process.
Hi, I'm Mrs. Mhlongo, and I'll be delving into the issue of maintenance during divorce proceedings. Let's start with child maintenance. In matters relating to children, the Children's Act applies. Its aim is to give effect to certain rights of children as contained in the Constitution, to set out principles relating to the care and protection of children, to define parental responsibilities and rights, to make further provision regarding children's courts, and to provide for partial care of children, to provide for early childhood development, and to provide for the issuing of contribution orders, amongst other things. Let's go to care. When the Children's Act was implemented, the term custody seems to have been replaced with the term care, which, according to the Act, includes providing the child with a suitable place to live, providing living conditions that are conducive to the child's health, well-being, and development, providing the necessary financial support, safeguarding and promoting the child's well-being, protecting the child from maltreatment, abuse, neglect, degradation, discrimination, exploitation, and any other physical, emotional, or moral harm or hazards. Respecting, protecting, promoting, and securing the fulfillment of and guarding against any infringement of the child's rights as set out in the Bill of Rights and Principles set out in Chapter 2 of the Act. Guiding, directing, and securing the child's education and upbringing, including religious and cultural education in a manner appropriate to the child's age, maturity, and stage of development. Guiding, advising, and assisting in decisions to be taken by a child in a manner appropriate to the child's age, maturity, and stage of development. Guiding the behavior of the child in a humane manner, maintaining a sound relationship with the child, accommodating any special needs that the child may have, and ensuring that the child's best interests are the overriding concern in all matters affecting the child. Let's go to contact. When the Children's Act was implemented, the term access was replaced with the term contact, which, according to the Act, is defined as maintaining a personal relationship with the child, and if the child lives with someone else, communicating on a regular basis with the child in person, including visiting the child or being visited by the child, or communicating on a regular basis with the child in any other manner, including by post, by telephone, or by any other means of electronic communication such as Skype, email, and Facebook. A child has a right to have contact with both his or her parents. When determining the amount of contact and form of contact a parent should have with the child, the above mentioned factors contained in the Children's Act must be considered. Every situation is unique, and the outcome will depend on the facts of each case. The parent's relationship with the child's stage of development, and where applicable, the child's wishes. Going to major decisions. Before a person holding parental responsibilities and rights in respect of a child takes any decision involving the child, that person must give due consideration to any views and wishes expressed by the child, bearing in mind the child's age, maturity, and stage of development. A decision, as referred, is any decision in connection with the administering and safeguarding of the child's property and property interests, assist or represent the child in administrative, contractual, and other legal matters, or give or refuse any consent required by law in respect of the child. A decision affecting contact between the child and a co-holder of parental rights and responsibilities. Regarding the assignment of guardianship or care in respect of the child to another person, or which is likely to significantly change or have an adverse effect on the child's living condition, education, health, personal relations with the parent or family member, or generally the child's well-being. Before a person holding parental responsibilities and rights in respect of a child takes any decisions as contemplated, that person must give due consideration to any views and wishes expressed by any co-holder of parental responsibilities and rights in respect of the child. A decision, as aforementioned, is any decision which is likely to change significantly or have a significant adverse effect on the co-holder's exercise of parental responsibilities and rights in respect of the child. Going to the primary caregiver. A person can either have full or specific parental responsibilities and rights in respect of a child. The parental responsibilities and rights that a person may have in respect of a child include the responsibility and right to care for the child, maintain contact with the child, act as a guardian for the child, and contribute to the maintenance of the child. Subject to the act, a parent or any other person who acts as a guardian of a child must administer and safeguard the child's property and property interests, assist or represent the child in administrative, contractual, and other legal matters, give or refuse any consent required by law in respect of the child, including consent to the child's marriage, consent to the child's adoption, consent to the child's departure or removal from the Republic, consent to the child's application for a passport, and consent to the alienation or encumbrance of any immovable property of the child. Whenever more than one person has guardianship of a child, each one of them is competent subject to the terms of any parental plan or any other law or any order of a competent court to the contrary, to exercise independently and without the consent of any other right or responsibility arising from such guardianship. Unless a competent court orders otherwise, the consent of all the persons that have guardianship in respect of a child is necessary in respect of matters on marriage, adoption, departure, and alienation of property. FAMAC, the Family Mediators Association of the Western Cape, has its origins in the Western Cape, where an interest group was formed in 1988 to look into the possibility of offering divorce or a family mediation service. Mediation is a voluntary and confidential process which parties are helped by a neutral professional to explore possibilities of resolving issues and dispute between themselves by agreement without adjudication. The Family Advocate and its endorsement. The Family Advocate deals with endorsements of settlement agreements and parental plans in divorce matters, as well as disputes between parents or family members over the parental responsibility and rights of children. The Family Advocate is there to ensure that settlement agreements are in line with the children's best interests, and as well as to provide recommendations when parents cannot agree to custody arrangements during their divorce. This would include visitation of children, how often and whether such contact should or should not be supervised. The recommendations of the Family Advocate are intended to assist the court in adjudicating the matter and arriving at a particular order. It is separate. The recommendation itself is not enforceable, which may also be paid in addition to spousal maintenance. The Family Advocate is a neutral institution and cannot act as the representative of either litigant in the matter. In conclusion, as we wrap up our exploration today, we've covered the essential checkpoints on your child maintenance for a specified period, especially during referred to as rehabilitative maintenance, or for an indeterminate time until which the other person passes on or remarries. Rehabilitative maintenance is maintenance which operates for a period of time which is limited and is intended to assist the person receiving same towards becoming financially independent of their former spouse. Once the period specified in the order comes to an end, no further maintenance can be claimed. What are the factors taken into account to determine spousal maintenance? The existing and prospective means of each party, the earning capacities of each party, the financial needs and obligations of each party, the parties' ages, the duration of the marriage, the standard of living enjoyed by the parties prior to the divorce, the conduct of either party leading up to divorce, where this is relevant to the reasons for the breakdown of the marriage, any transfer of assets to be made in terms of a redistribution order, and any other factor which the court, in its opinion, believes should be considered. What are the consequences of not claiming spousal maintenance? Spousal maintenance cannot be granted post-divorce. Therefore, a spouse cannot lay a claim for spousal maintenance against a former spouse if an order for spousal maintenance was not made in terms when their marriage was dissolved. If the ex-spouse
Hi, my
has
name is
not
Annelies Petzer, and I will be shedding some
incorporated
light on the
a
powerful role that mediation
order
can
for
play in the
maintenance
context of
in its
divorces.
final divorce
So, what
order,
is
it
mediation?
is forever
Mediation is a
forfeited
voluntary and
and cannot
confidential
be
process
claimed.
that allows divorcing couples
That is all
to take
with
control of their own destiny.
relations
It's
to
a
maintenance
collaborative, non
in
adversarial method where a
family
neutral
law
third party,
matters.
called a
Thank you
mediator,
so much.
guides the parties through discussions to explore solutions and reach agreements on various issues. In the context of divorces, effective communication is paramount. Mediation creates a safe space for open dialogue, fostering a deeper understanding of each party's concerns, interests, and priorities. This is especially crucial when dealing with substantial assets, intricate financial arrangements, and complex family dynamics. So you might be asking how mediation works. So mediation typically involves a series of sessions during which the mediator facilitates discussions on specific topics including property division, spousal support, child custody, and any other pertinent issues. The process is tailored to the unique needs of each couple, allowing for flexibility in addressing their specific concerns. While the mediator facilitates communication, each party has the option to consult with their individual attorneys throughout the process. This therefore ensures that the decisions made during the mediation process align with the legal standards and protects the rights and interests of each party involved. So you might also be wondering what the aim or the purpose of the mediation is. So, the primary goal of mediation is to empower divorcing couples to make informed decisions about their future. Rather than having a court impose decisions upon them, mediation allows the parties to actively participate in crafting agreements that reflect their values, goals, and unique circumstances. Mediation also prioritizes preserving relationships. This is particularly important when ongoing business partnerships or shared financial interests or children are involved. By fostering cooperation, mediation helps mitigate the potential for long term animosity and facilitates a smoother transition to post divorce life. Sometimes I'm asked whether mediation isn't a sign of weakness. So, if you're willing to mediate, is that not a sign of weakness? My opinion, not at all. Choosing mediation is a proactive and strategic decision that demonstrates strength and resilience. It shows a willingness to face the challenges of divorce head on, seeking a solution that is not only legally sound but also emotionally and financially sustainable. Mediation is a testament to the ability to navigate the complexities with grace and strength. Contrary to the misconception that litigation is a stronger stance, mediation is often more efficient and is more cost effective. Divorces can become draining in a courtroom battle, and mediation offers a streamlined process, reducing legal fees and allowing for a quicker resolution. Mediation is not just about dividing assets, it's about paving the way for emotional healing. By fostering a collaborative atmosphere and encouraging parties to focus on the future rather than dwelling on the past, mediation becomes a valuable tool for the emotional recovery and the redefinition of the relationships post divorce.
Now, as we are nearing the end of our session today, I would like to remind you that once the divorce procedures have been finalized and you are in hand with court order, it is critically important to ensure that you update your will. Now, if you are already in the process or your mind is made up, you are going to proceed with a divorce process, or you have received court process, then it is probably quite useful for you to start having these conversations now already. And of course, if you choose us to assist you in this process, we will also assist you through it to make an interim provision and once the process is finalized, for us to finalize it as well. But the point is, with this change in circumstance, you would need to update your will. You would need to reconsider potentially who the guardians of your minor children would be. You would need to reconsider if your spouse inherits, or if we should set up a testamentary trust for the children, or whether there would be scope for someone else to inherit. Remember, there is a piece of legislation called the Maintenance of Surviving Spouses Act, which effectively means that the reciprocal duty of support is only severed once there is a final court order severing the marital relationship. And up until that point, we are not able to disinherit our estranged or soon-to-be ex-spouse until that process is finalized. So that's why it's important to take proper advice as part of this process. Then, of course, to relook all the insurance policies you may have, whether it's life insurance policies, or whether it's an endowment policy, or even if it is a pension or provident fund policy. Important for you to nominate the beneficiaries, and again, if minors are involved, to consider setting up a testamentary trust or similar vehicle in order to ensure that they are taken care of. You should also speak to your financial advisor or broker to reassess your provisions that you've made with the soon-to-be changed circumstance, and possibly again once the court order has been finalized. That brings us to the end of the session today. Thank you so much from all of us on the panel today for joining us. We really hope that this was useful and that it will help you navigate this really difficult time with a sense of confidence. Should you wish to engage with us in relation to any of the legal needs that you may have in a separation or a divorce proceeding, or if you need to revise your child or spousal maintenance provisions, or if you need the estate planning to be revisited and a new will to be drafted, please do not hesitate to contact us. Remember, we offer an exclusive free 10-minute free consultation when you can ask any additional questions. We would be happy to answer them and for us to then assist you with a full consultation. Our rates are on our website. With that then, thank you so much for choosing to spend your time with us. We do appreciate it and we wish you all the very best.